Hello and welcome to the BRR Legal Brief, where we bring you the latest legal issues affecting corporate Australia. I'm Kate Ritchie. Well, last week a hoax press release caused havoc to Whitehaven's share price, with an 8.8% drop in the share price before the hoax was acknowledged and the share price recovered. Joining me to discuss is Philip Podzabenko, who's a partner at Herbert Smith Freehills. Philip, thank you for joining me in the studio.
Thank you very much for inviting me, Kate. Pleasure to be here.
Well, Philip, before we look at the case in more detail, can you give us a background on what we saw unfold last week?
Look, it really all happened over the course of a couple of hours on Monday. As you mentioned, late on Monday morning, a hoax press release was issued to a number of news outlets. That was taken up by the press, and within about 20 minutes of being issued, the first news wires hit the wires. Mm-hmm. Article was published at 12:18, and then over the course of the next 20 or so minutes, the various other news outlets picked up the story and published further, and the share price for Whitehaven dropped from $3.52 down to $3.21. Shortly after finding out about the hoax press release, Whitehaven sought a trading halt, which was given by the ASX at 12:41. It investigated the hoax press release, concluded that it was in fact untrue, published it at 1:04, a corrective ASX release, mm-hmm. And when market trading resumed in Whitehaven shares at 1:30, the share price returned to $3.52. So what it really demonstrates is both the speed with which the markets operate, mm-hmm. but also some of the concerns and emerging risks for market participants and investors arising out of both instantaneous communications and also social media.
Well, Philip, the ASX will not be reversing any of the trades. What recourse is available for any investors who lost money?
The Corporations Act provides a number of bases for investors to seek compensation from the perpetrators, including for false and misleading statements and also for misleading or deceptive conduct. I think the real question is whether those sorts of remedies would be attractive to investors, mm-hmm. both having regard to the actual amounts that investors lost. Although references are made to $300 million being wiped off the Whitehaven share price, the actual amount that investors lost through trades is considerably less. Mm-hmm. I think also relevant will be the perpetrator's ability to pay. So, as I think was mentioned in some of the press reports last week, there's no point in squeezing blood out of a stone.
Well, investors may not want to pursue, but what about the corporate regulator? What are some of the avenues of prosecution available to it?
The Corporations Act provides really some quite powerful remedies for ASIC in seeking to prosecute and sanction this sort of behaviour. Again, for breaches of the false or misleading statement provisions and also for market manipulation, there are a number of remedies, including specifically an ability to seek civil penalties of up to $765,000, mm-hmm. as well as imprisonment for up to 10 years. I think it's important to bear in mind, particularly in the context of the imprisonment remedy, that the courts aren't going to impose that unless there is no other avenue that they can see that's appropriate. And also in imposing a term, they'll actually seek a term that is reflective of the severity of the misconduct. There have been references in the press to previous regulators seeking cancellation of trades affected by the hoax. I think when you look at those previous circumstances, what had occurred was that the hoax was actually perpetrated through the ASX itself, mm-hmm. rather than outside it. And so some of the regulatory imperatives were a little bit different there. So I'm not sure whether ASIC would take that sort of action in this context.
And just finally, what lessons can we learn from Whitehaven?
Well, I guess, as I mentioned at the beginning of the interview, it does demonstrate some of the risks posed by new media to investors. I think there are probably three lessons that are coming out of this that I can see. The first of which, I can see an emerging trend where companies increasingly adopt a practice or actually develop a practice of monitoring not only official media outlets but also social media and the internet, so that they can respond quickly to press reports or hoax stories or similar relating to the share price. So I can see that as an emerging trend. I think the second thing that I can see, and it's something actually that ASIC has already gotten onto, which was that ASIC has stated in its takeover law reform proposals that a review of social media is on the agenda and the implications of it for investors. I think the last of the lessons that are coming out of this, again, is something that we've already seen in the press over the course of last week, and that is really a review by internal compliance teams within the various news outlets of systems that they have in place for verifying reports before they're released to the public.
Some important things for people to do. Philip, thank you so much for joining us in the studio today.
Thank you very much.
And viewers, thank you for joining us as well. We hope that you can join us next week for our legal brief.